let's see. Oh, can you bring up Mr. Driggs?
Yes.
Okay. State of Michigan versus Charles Davis, 25-02436. Appearance, please.
For the people.
Assistant Public Defender John Lee on behalf of Charles Davis, who is present and standing by right.
Today was the date scheduled for Mr. Davis to have a preliminary examination on a motor vehicle unlawful driving away. There was also a domestic violence second in this file. How are we proceeding?
Your Honor, the plaintiff victim in this matter has not appeared, and our office has received a recant, and so I do not believe at this time that we will be able to proceed victimless, so I would expect a motion from the defense.
I'm sorry. There was a witness that failed to appear and your office received a recant?
That is correct, Your Honor, and that has been communicated to the defense counsel.
Okay, but your office is not going to withdraw the charges?
We have not had contact with the victim since then. So
Yeah.
I don't know if we weren't able to look into whether or not it was a coerced statement. Or
if it's actual, it was
if it was we weren't able to investigate whether or not it was a coerced recant or an actual recant.
Okay.
So I will leave the motion to the defense.
So you're not sure they've not been able to verify when it was a valid recant. Could have been anybody on the phone, is what you're saying.
That is correct. The name was stated, but we don't.
Counsel?
Your Honor, given that the state is unable to proceed, we make a motion for dismissal.
Motion to dismiss is granted without prejudice. The people do have the right to reissue this against you. Do you understand that? Is that a yes?
Yes.
Okay, we'll get you a copy of dismissal in just a moment. You're on GPS tether.
Yes, I am.
You need to go back down there so they can remove the tether, okay? You'll notify me. You have any questions?
No.
Any additional matters for the record?
Not going to be on.
Nothing for the defense. Thank you.
Thank you. He would like a copy of the dismissal. He should wait for a copy.
Yeah. Same as we did for this channel, basically. I guess consent could be amendment, but then.
That wouldn't necessarily happen.
Why are they not letting you find it? So that will happen in sugar.
This that tool, you gotta come up here by email.
Yes, to take the tether off. Yes, I think, or you probably could go straight to JSG too as well, but we will notify them that it can be removed.
Yeah, the amendment, so not the original charge.
To JSG?
I know it's probably not the original. Yeah.
So if we have to.
Right, it might just be easier to go back up there to have it removed,
And
Still remove it.
because I can't confirm if there's anyone at JSG
To add them.
to remove
That
it, but,
operators are basically first free trial.
or what address they would remove it from if
I mean,
it's at JSG. So he should probably just go up to the Ingham County Jail where he got it put on and they can remove
Eventually,
it.
I'll go
Okay.
down.
And we'll
It's
send
just whether or not
notification
the
now.
offer preserved.
Okay, thank you.
You're welcome.
yeah, that's because I have the proofs for or 1,000 or 20,000. That's why we're
Amending.
going away, and then instead of just having one. I don't want to get up there and then
Right.
not have the right charges, you know.
Right. No, you're right about that. Okay.
We just haven't been able to run away.
Yeah, we've been.
On the record in the matter of the state of Michigan versus Travis Driggs, 25-02109, appearance, please.
Thank you, Your Honor. Cassidy Kachukas for the people.
Public Defender John Lee appearing on behalf of Travis D. Driggs.
Okay, Mr. Driggs was scheduled for a preliminary examination today. This is for larceny. Are we running this exam?
It's my understanding that the defendant intends to waive his right to a preliminary examination in this matter, contingent upon the amendment of the current charges. The current charge would have to be amended to, I guess you could dismiss the first charge and add to the correct charges should be one count of entry into a building without entry without breaking with intent to commit a larceny or felony therein. And another count of larceny from a building. And his offer in the matter that he's preserving with this waiver is that he would plead to the one count of larceny from a building, and the entry without breaking with intent to commit a larceny or felony therein would be dismissed. And I have the pack codes if the court would like those.
Okay, you want to amend count 1 to the entry without breaking with intent to commit larceny or felony. What's the pack code for that one?
The pack code is 750.111.
And then added count 2 is going to be larceny.
Larceny from a building, they pack code of 750.360.
And so wants to waive his examination with that understanding.
Yes, Your Honor.
I'm drawing it this time.
Motion to approach, Your Honor.
Thank you. Mr. Driggs can stand. Mr. Driggs, you understand your right in this matter to proceed to a preliminary examination because you are being charged with felony. You understand your right to have the prosecution first establish on the record here at the district court that they have sufficient probable cause that the felonies were committed and there's sufficient probable cause to charge you as the individual who committed the alleged felonies.
What is that?
You have the right to have the prosecution put forth evidence in the district court to establish they have sufficient probable cause that a felony was committed. Do you understand that?
Yes.
You also have the right to have them put forth evidence to establish that they have sufficient probable cause to charge you as the person who allegedly committed the felony. You understand that?
Charge me, yes.
Yes. And you wish to waive your right to have that hearing in this court?
Yes, ma'am.
Anyone coercing you to waive that right?
Yes.
Who's coercing
No
you?
coercion.
Okay. Any promises if you waive that right?
No.
Your bind over date is September 10th. That's the date that the circuit court receives the file from the district court. You do not have to appear in the circuit court on that date, okay?
Okay.
Your next court date will be a pre-trial. Your attorney will be made aware of that, okay?
Okay.
Is being held on something other than this?
Yes, I have a parole detainer currently, and I have 2 holds, one out of Clinton and one out of Clare County. That's why I was gonna try and ask the court today for a personal conduct bond, so I can start getting those matters taken care of while I'm waiting to go to court on this. Otherwise, it's gonna hold me in Ingham County Jail, and I don't know if I'll ever be able to get sent over there on a writ or anything, you know what I mean?
You have a parole detainer and then you have the holds where?
Clinton and Clare. 2 different counties. Awesome. Clinton is for unpaid fines, and I believe Clare is the same thing.
Unpaid fine.
Unpaid fines because well, it's critical hit.
Well, those aren't serious.
No, Your Honor. He's looking for a reduction in bond and or a personal recognizance bond, so he can get out, start working, start getting his fines paid off. He's also got a hernia condition. that
I've also
he's
got
been
hernia.
dealing with.
It's a condition like that. It's actually sort of, you know.
Bond's only 3,010%. You want it lower than that?
Can't afford 3,000, 10%.
I haven't been able to work lately because of my hernia.
So then getting out, you're not gonna be able to work still.
Well, I'll be able to get my hernia taken care of, and then I can start from there. Well, I'm gonna get surgery while I'm in jail.
Okay, but you don't come to court.
I did come to court when I had the paperwork, and the only reason I didn't attend court last time was because I didn't receive the paperwork and only they even had court. I don't have a good record then in attending court, but I do plan to try and get things taken care of.
So you don't have a.
I don't have a great
what?
court record for showing court no man, but I do intend to.
Right.
My life.
And then you got, that's why you got holds in other courts, because you're not taking care of
But
your
they're up
business.
north too, and I didn't.
Where do you live?
Currently I'm in Lansing.
Where?
Oops, I'm not sure the exact address.
That you don't know where you live?
I have a mailing address.
Nope,
I use.
didn't ask you that.
I do know where I live. I live in
Where
Twin
do you-
Oaks apartment building. It's on Waverly and by Jolly.
Where, yeah, I know where the
Apartment.
apartments
Yeah.
are. Where do you live there?
I live with a friend of mine. I stay with a friend of mine. Right now.
Okay, so you have a friend that lives there,
Yes.
and that friend said it was okay for you to stay there, but you don't know the address or the
I
apartment
don't
number.
know the exact address. I do know the apartment number.
How
yes.
long have you been staying there?
6 months. I can't think of the address. I do know the address.
What's your phone number?
I currently don't have a phone. No. Not a number. Not a constant number that I've ever been reached at. No.
Really, since, how long has that been the case?
Since I was absconding on parole. Last year, probably.
So why did you give the magistrate a phone number last time? Or if you saw her?
Well, man,
Excuse me?
I didn't give the magistrate a phone number last night, sorry.
So Magistrate Milmer just made a phone number up and a
Or she
mailing,
may have
and a
used
mail
that.
only address?
She may have used an old phone number.
No, she didn't.
What's the number?
How, she wrote mail only, which you just told me you can give me a mail only address, which means you gave her a mail only address,
Right,
correct?
I gave her a number.
And then she asked you what your phone number was at your arraignment, because that's a required question that we ask. And you told her a number.
I don't believe I did tell her a number. Not that I'm aware of. I don't have any number to give her. Why would I tell her a number?
Okay. So you don't know your address, you don't have a number to give her, you want me to lower the bond, and then you want your mail to go to someone else's address. Whose
No,
address is this, a
This
mail?
is a Advent House Ministries. I go there almost every day.
Okay, you want your,
I
so
have a
you gave-
caseworker there, Jack. I have a voucher there to try and get into a housing. There's a lot of different things I got going on that are good for me. I just gotta get them in order. You know, and when I was on the run of absconding, I wasn't able to do that because I was afraid of going back to jail, going back to prison. All because of some stuff that happened last year, you know, and now that this stuff's getting put behind me, I'd like to be able to try and make my life start going in the right positive direction again, you know what I mean?
I get it. Well, you're obviously know that you're not eligible for a personal recognizance bond. You do know that, correct?
Why is that?
Were you under court supervision or parole at the time of this alleged incident?
I was absconding.
That would make you ineligible for a personal recognizance bond. That, yes. You didn't know that?
I don't know.
Yeah, well, now you know. If you're already on probation or parole, and then you pick up a new case, then that gives the presumption that you're not gonna follow court order. So that makes you no longer a candidate for a personal recognizance bond, which is why she gave you a bond of 3,000, 10%. I can lower it, but I will not give you a personal recognizance bond. I will amend your bond to 2,000, 10%.
I'm gonna have to send Rich then to these other counties to try and get this taken care of. I don't know how to build bond all. That's not gonna.
Correct. You can send bonds or communications if they want to writ you, then that's up to them. If it's for fines and costs, it's not likely that they're going to do that because it costs taxpayer money to do that, to try to collect money from you that you obviously don't have at this time. So that one, I think your parole hold is probably primary right now, more than anything else, but it'll get taken care of, I'm sure.
Okay. Another thing is like the burden of proof on this case is, there is none. I didn't do this crime.
No, the burden of proof, there's definitely a burden of proof. There's always a burden of proof. They have to prove each element beyond a reasonable doubt.
Yeah,
So maybe what you mean, the evidence.
they don't
there's
have
no
evidence.
evidence.
There is no evidence.
Okay, I don't know, because I'm not here to hear evidence on this
But
case.
honestly, I didn't commit a crime. so.
Okay, well, you are maintaining your innocence, and that's why a not guilty plea has been entered on your behalf. So this matter will continue to trial unless you change your mind about your innocence. And so until then, the matter is just going to be processed now, getting prepared for a trial date. Okay.
Okay.
Do you have any other questions, sir? Any additional matters for the record?
Not from the people, Your Honor.
Not for the defense, thank you.
Thank you. You're all set.
Can I have a copy of the pictures of
Can I have them?
All right, let's talk about that. This docket was a blend of clean resolutions, a negotiated plea structure, and one particularly spirited bond review that turned into a mini cross-examination was Charles Davis, whose case unraveled quickly. He was facing a domestic violence second offense charge alongside another count, but the prosecution admitted their witness failed to appear, and they'd received a recanting statement, though they hadn't been able to verify if it was genuine or coerced. With no evidence ready to move forward, defense counsel moved to dismiss. Judge Kristen D. Simmons granted the dismissal without prejudice, meaning the case could be reissued if new evidence came to light.